serving the defendant. So once you have filed your complaint with the clerk and received a trial date, you must arrange to have the defendant served with the complaint and also the packet of information that was provided to you by the clerk's office. You may not serve the complaint and summons yourself. This is very important. And bad service means no service. So if you don't serve properly, it's not enough that the defendant simply knows they're being sued. They have to be served properly under the law. The defendant must be served at least 15 days before trial. So you should remember this when you're filing your complaint and selecting your hearing date, because you have to leave yourself enough time to find the person and serve them. And this can sometimes be a lengthy process. The person who serves has to fill out an affidavit of service. That's the last page of the notice. That's form JDF 250 that we've been looking at. That provides proof that the defendant was given formal notice of the claims, the trial date, and where to appear. It also must be notarized. And you can find a notary public at a bank, the library, or certain UPS and FedEx Kinko stores, among other places. You have to provide the court with the affidavit of service either ahead of time or before your trial. And it's best if you do it before your trial date. That way, if the defendant doesn't show, then you can get a default judgment in your favor. So as long as you've served correctly, you are being served with a complaint, not these are for you. The person being served cannot refuse. So they can leave the complaint lying on the street, they can throw it in the trash. As long as they've been properly served, you will get a default judgment if they don't show. Who can serve? So important reminder, not you. You cannot serve. The sheriff can serve, the sheriff in the county in which you're suing. The sheriff is reliable and persistent. There is a fee associated with that. Depends on the county. A private process server can also serve. There's also a fee associated with that. It depends on who you use. You can find that individual on the internet or the Yellow Pages. You can have a friend. The friend must be over 18 and not related to either party. If the person to be served is likely to be hostile or aggressive to the server, you probably shouldn't use a friend. So consider that when you're making your decision. And also the person serving must be polite. So another thing to consider when you're deciding whether to use a friend. The last option, and one that's not very reliable and one that's not highly recommended, is certified mail. Only the clerk of the court can do this. You need a green card with a signature of the defendant. Can't be any other signature, so you have to have that signature from the actual defendant. And if certified mail cannot be completed, then you'll have to serve some other way. So it's a last-ditch effort. It shouldn't be your first choice. Substitution of service. Personal service is best, but you can also serve at the usual place of abode, so that's where a person lives, with some member of the family over 18. And the affidavit of service has to include the name of the person served, the address where the subpoena was served, and also the person's relationship to the defendant. You can serve at the defendant's usual place of business with a supervisor, secretary, administrative assistant, bookkeeper, human resources representative, or managing agent who's over 18. And then the affidavit of service has to include the person's name, title, or job responsibilities, and state that the person served is over 18. You can serve any partner in a partnership if you're suing a partnership. And if you're suing a corporation, you can serve the registered officer or registered agent, which, as we discussed, you can find on the Secretary of State's website. You need to state clearly on the affidavit of service who was served and what was served. So for defendants, in responding to a complaint, if you've been served with a complaint, you must file an answer and pay a filing fee. If you do not file an answer and/or refuse to pay the filing fee, the court may enter a default judgment against you. So that's an automatic judgment in favor of the plaintiff. The answer can be filed on or before the trial date. But note that if you wait until the trial actually begins, then the time it takes to file will be deducted from your allotted trial time. And as we will discuss, your allotted trial time is rather brief. So it makes sense to do it beforehand and not have it deducted from your time. The answer form is on page 2 of the complaint. So that's JDF 250 that we've been discussing.